So we have a massive update in the legal battle that could actually bring down the National Firearms Act. The DOJ has officially filed its response to the Fifth Circuit regarding a high-stakes petition for a rehearing en banc when it comes to suppressors. The federal government is scrambling to defend the NFA's registration and taxation schemes after being backed into a corner by a panel of judges. If you've been following the channel for a while, you will know that this case started when the Fifth Circuit panel made history by actually ruling that suppressors are in fact arms that are protected by the Second Amendment. However, because of an older circuit precedent, the panel was actually trapped into upholding the conviction anyway against the individual. That led two conservative judges on that very panel to write a critical concurrence telling the defendant to actually seek en banc review in the Fifth Circuit to wipe out that older precedent. The Fifth Circuit gave the DOJ a very strict, non-extendable deadline to respond to this petition, and that response has now been filed. Today, we're going to dive deep into the full backstory of this case. We're actually going to be breaking down also the DOJ's desperate filing to deny review to this case, and also we're going to talk about why the NFA is now currently on thin ice because of this challenge. Now, before we jump into what is going on in this critical suppressor NFA case, if you like this type of content and you want to make sure you get it going forward, make sure you subscribe to the channel and also turn on all notifications to make sure you never miss these videos when I release them. Now, to understand how critical this case is, we have to look back at the devastating precedent that just trapped this new defendant in the case. Now, it all stems from a case called U.S. versus Peterson, a major suppressor challenge that we have covered a lot on this channel. Now, in that case, law enforcement raided Mr. Peterson's home-based FFL, found an unregistered suppressor, a solvent trap in his bedroom safe, and the DOJ hit him with a standalone NFA violation that carried a 24-month prison sentence, which he is currently serving. Now, Mr. Peterson challenged this conviction based on a theory that the NFA is a violation of the Second Amendment and does not align with Bruin's framework. Now, in that case, the Fifth Circuit did something incredibly dangerous. They claimed that the NFA is presumptively lawful because it operates like a shall-issue licensing system. Essentially, that panel's ruling established a rule saying that as long as the government has an objective process for registering and taxing you, the restriction can in fact survive under Bruin. Peterson appealed to the Supreme Court, but the Supreme Court refused to actually step in. Because of that inaction and that denial by the Supreme Court, Peterson's final request to actually modify his conviction and his confinement to just house arrest was denied, and he's currently serving prison time in a federal prison. Now, his case became a tragic real-world example of the state of this current law. The government could essentially admit that an item is protected by the Second Amendment, but still lock you in a cage for failing to register it. That brings us directly to this new challenge in this new case and a decision that recently came in a case called U.S. versus Comeau. Now, Mr. Comeau was actually prosecuted under the exact same federal statute for possessing an unregistered suppressor. He argued that the NFA violated his constitutional rights, but the district court flatly rejected that claim, and they argued that silencers are dangerous and unusual weapons, not protected by the Second Amendment. Now, he then appealed up to the Fifth Circuit, and this new panel that reviewed his case did something unprecedented. The court explicitly ruled that suppressors absolutely are in fact protected arms under the Second Amendment. So writing for the court, Judge Jerry Smith dismantled the government's current arguments. The court recognized that suppressors reduce loudness, lower the risk of hearing loss, eliminate muzzle blasts, and also can increase accuracy. The court ruled that these are critical functions that make a firearm safer and more effective for the core lawful purposes of self-defense. And under Bruin, an item does not have to be strictly necessary for a gun to actually function. Instead, it just has to facilitate armed self-defense. Now, this was a massive constitutional win. The Fifth Circuit has officially cemented into the law that silencers are protected by the Second Amendment. This also created a very direct circuit split on this very issue where the Ninth Circuit recently ruled that suppressors are not protected arms. Now, you may be thinking, if suppressors are protected arms, if that's the way the Fifth Circuit ruled, why was Mr. Comeau's conviction still affirmed and upheld? Well, this is because of some frustrating judicial realities and the frustrating reality really when it comes to the judicial system and some precedent that was existing in the Fifth Circuit. Under the legal doctrine known as the rule of orderliness, a three-judge panel of an appellate court is completely bound by the decisions by a prior panel in the same circuit. Because the previous panel in Peterson manufactured a rule saying that the NFA's registration scheme is presumptively lawful unless you can prove exorbitant fees or lengthy wait times, This panel here in the Comeau case really had their hands tied. The judges openly admitted that because of Peterson and that precedent, it controlled and they had to rule in this specific way. But this is where this case kind of took a critical turn and why the ATF is so concerned when it comes to the NFA and suppressors. In this case, Circuit Judge Edith Brown Clement, joined by Judge Stuart Kyle Duncan, issued a fiery concurring opinion aimed directly at destroying that Peterson precedent. They wrote to state bluntly that Peterson was a massive mistake that needs to be revisited and overturned by the full en banc panel court in the Fifth Circuit. Now, after that concurrence was issued, Mr. Comeau's legal team did not waste any time, and they immediately sought en banc panel review in this case. On July 2nd, they officially filed that petition for a rehearing en banc, demanding that the full court of the Fifth Circuit revisit that Peterson ruling and essentially throw it in the trash. The second the petition hit the docket, the court automatically canceled the mandate, freezing this case in place. The Fifth Circuit is clearly taking this incredibly seriously, and on July 8th, the court issued a directive explicitly ordering that the DOJ needed to file its response, its opposition, by July 20th. And now the government had to file their formal response, and we have that response from the DOJ, and the DOJ is pulling out every stop to try to prevent the full Fifth Circuit en banc panel from hearing this case. Now, here are the main arguments that the DOJ puts forward for why this case needs to be denied en banc panel review. Now, the first argument is that footnote 9 in Bruin shields shall issue regimes. The DOJ argues that Peterson was correct and that licensing and registration schemes do not implicate the Second Amendment unless a defendant proves administrative abuse. Now, the problem with that type of rationale is that footnote 9 in Bruin was applying and looking at public carry licensing, not federal registration and taxation schemes for possessing basic firearms equipment within your home. Now, the second argument that the DOJ puts forward is that they believe historical knife laws and knife taxes actually justify these types of silencer registrations and restrictions. Now, in contrast, the other side argues that these localized state tax statutes from the 1800s on these specific edged weapons is not nearly equivalent to the nationwide federal ban and registration process that is put in place by the ATF through the NFA. Now, the final argument made by the DOJ in this opposition is that processing times are faster and the taxes are currently $0. Now, the problem with that and what Mr. Comeau will argue is that speed or cost of an administrative hurdle does not make an unconstitutional infringement suddenly constitutional. And the fact that something is simply fast and does not cost a lot does not mean that it's suddenly constitutional. So what does this now mean going forward? Well, it means that the battle over the NFA has officially accelerated because two influential judges have already written a literal roadmap detailing exactly why this current circuit law is unconstitutional, and the full Fifth Circuit is actually poised to potentially evaluate that and determine if they need to get rid of that precedent. If the full court goes en banc, they are completely free to actually do away with the rule of orderliness. They can completely go away from that Peterson framework. They can throw that precedent out and rule that, yes, suppressors are protected arms, and yes, that the NFA is a violation of the Second Amendment, that it does not operate like a permissible shall issue system. A full court rehearing and positive decision here would also help out Mr. Peterson, who is currently sitting in prison because of this incorrect ruling. So the cracks in the NFA today are wider than they ever have been. The courts have officially acknowledged that suppressors are protected arms, and the clock is now ticking on that bad precedent, which is currently keeping the NFA alive, especially in the Fifth Circuit. And the DOJ, in their response, in their opposition here, is trying to do everything. They're pulling in every argument to prevent this type of review. So let me know what you think down below in the comment section. Do you think that the Fifth Circuit Peterson precedent is going to be overturned? Do you think that the full en banc panel here is going to rule that suppressors are in fact protected arms and that the NFA does not operate like a permissible shall issue system? Do they believe that there is any historical analogs that support the NFA, or are they going to completely just wipe out the NFA based on it being a violation of the Second Amendment? Let me know your thoughts down below in the comment section. If you like this type of video and you would like to get this going forward, make sure you like, comment, subscribe, and turn on all notifications to never miss these videos once I release them. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.